Now let's move on to our next speaker. We brought your next speaker to you all the way from California with us because he has such an incredible story to share with you. His story is truly the story of David versus Goliath. You know, you hear about that kind of story not very often, but it's a David and Goliath kind of thing, which I like to suggest could happen a lot more if people just do a little homework. You just, be prepared to win. You know, after all, you can't expect to win without doing any preparation, any work at all. You got to do something. And this person, gentleman, certainly has. You know, in California, we have two federal governments. You guys didn't know that? Yeah, we do. We have two big, distant governments that don't care about people, because the masses are so huge. The Union of American States, when it was originally formed back in 1776, was only 7 million. That was a whole union. Right now in California, there's over 30 million people. Okay, and Sacramento, the capital, is far from Los Angeles, even far from San Francisco, the major population centers. So they're very arrogant, out of control, and they have a taxing agency called the California Franchise Tax Board, which is even more out of control than the IRS. In fact, Bill Compton and I we've been talking for the last couple of years. We call the IRS sheep little lambs. But we say, what happened to the old IRS that used to bring people in our laps all the time and come down hard on people? You know, people wake people up and they come to us and say, what do I do? IRS has gone to sleep, died, went to hell. Really? In California, I get about 7 calls that people are being harassed by the state of California Franchise Tax Board, that for every one IRS call I get. Just give you an idea how bad those guys are. And they're much more aggressive than the IRS. And are much more arbitrary. That they just do whatever they want to, and no matter how reasonable you are, they're just absolutely unreasonable and don't listen what's law, what's rules of evidence, what's procedure, this is just the way we do it, and that's it, So it particularly took us a lot of work to fight these guys. As you heard, criminally, Free Enterprise Society with illegal defense brought them down to their knees. They're prosecuting very, very, very few non-filers now in California because of criminally what Free Enterprise Society was able to accomplish against them. So they focus on civilly. That means trying to just steal money from you, illegally railroad you through. And this gentleman, who's a student of Freedom Law School, is one of the very few people who are actually allowed to sit in our live classes without charge. Everybody got to pay a price somehow, somewhere. There's no such thing as free lunch. But because when I met him, he was doing such a good job on his own, and I knew he was going to do some great things, I told him that I want to help him any way I could. Any knowledge that I have, maybe 10%, 20% of the stuff that I might share would be new stuff to him that he didn't know, that would give him better understanding, implement what he was doing better. So I did. And I'm glad I did, because it really ended up being a win for everybody. And as a result of his victory, he won a jury verdict, full-blown trial with the jury, 2 days. After less than 2 hours of jury deliberation, the jury gave him $250,000 cash verdict against the California Franchise Tax Board, and attorney's fees and expenses, and interest running for any delay that the government delayed in paying him. And the government abandoned the appeal they're going to do, because, as they'll tell you. And that's really awesome. that a citizen can do that. And as a result of his victory, they already have scaled back their criminal actions. And Paul can tell you more about that. But it's a true pleasure for me to have people like Paul Ballmer show that the average person does have a realistic chance of winning, despite the arrogance of our public servants. You know, you can have these guys follow the law if you want to be patient, do the work that needs to happen. And the other thing is, he like many others, has smaller victories, but this one was particularly sweet because he put more work into it. So the work that he put into it paid off far more in the long term. And I hope you have that vision for yourself. So please help us give a warm hand and welcome from Koreatown in Los Angeles, Mr. Paul Ballmer, the $250,000 man.
Well, it's really a pleasure to be here in Virginia. So beautiful outside. I went for a run this morning, and it's just a beautiful place to be, and God's been good to all of us. So we have to keep that in mind. And just because I won this case in California, I don't want you, hopefully I can share with you some of the ways in which you can use what I did in any other case or in any other part of the country. I will try and elaborate on some of that for you. Also, the fact, I think it's important to make the point that at one point, wherever you're at in this process, I was at that point also at some point. I started in the freedom movement actually in 1979. I bought Schiff's book, thought it was a bunch of whatever, and but I was really intrigued, and I stopped filing in 1980. I started going to seminars and buying books and buying tapes, and it's like, you know, when you go get a job, you don't know everything about the job, but you take the job in hopes that your superior is going to give you some training and that you're going to do some studying along the way. And that's what one of the ways that you have to look at this situation. It's really a lifetime kind of endeavor to begin to educate yourself in the ways how the courts work, how the agencies work, and through the gaining of that knowledge and information, the fear goes away. Because believe me, there were times when I had a lot of fear also. But in the beginning here, I just want to give you a little bit of my philosophy. Then I want to talk a little bit about the case, and then I want to tell you about some general things that I think are applicable in other legal situations. But I think it's important to understand that really the redress of grievance has been taken away from us in this country. The agencies are using their power to hold this over people. I've gotten quite a few calls from people since I've won this case, and people who have literally nothing, and the agencies are just stealing from them right and left, and the people don't have the wherewithal to do anything about it. The agencies have one thing in mind, and that is to make you surrender. They will make the hurdles so many, so high, so difficult along the way, but not insurmountable, okay? You have to understand that there is a way to surmount these hurdles. So it's sometimes difficult to stay involved, but if your focus is right and you have the right attitude, you can stay in there and hopefully do the same thing that I did. You see, I got to a point where I had to make a decision, and that decision was whether I was going to go forward or whether, let them get what they wanted, which was for me to surrender. And I had just decided that what they were doing was wrong, and I was brought up to live, to try and do the right thing, and I was not about to let them steal from me and just run over me. So, I mean, if someone came to your house in the middle of the night and held you at gunpoint and stole your car or your belongings or whatever, you would certainly do something about it, right? So why are we letting the agencies get away with what they're doing? Another thing that I want to bring out is that I think it's important that you, whatever your values are in life, that you get those values in order before you embark upon whatever action you decide that you want to take. And I'll just tell you what my values are. I won't tell you what order they're in. You can decide for yourself what your values are and what order that you want to put yours in. But it's business, health, family, spirituality, politics, and freedom. So 6 values, and once again you can decide, because the reason I bring this up is because you get to a point where when you're fighting someone, that your values become very, very important, and you have to decide what your values are, and they govern whether you're going to go forward and how you're going to go forward. So I had made a decision quite a few years ago that, as I said, once I found out what the Franchise Tax Board was really doing to people, that I was not going to go back, and I was going to do whatever it took to achieve whatever it was that I could achieve. If I had to go to jail, if I had to fight, whatever it was, but I wasn't going to let them steal from me. Now, you have to be aware that they have the guns, they have the power. They can come and take you out or me out in an instant, okay? They know where you live, they know all about you, they have all the information. So that's a given, okay? So from my perspective, only God can prevent that. Now, obviously, I don't run up and, do silly things, but that's where I put my trust. So hopefully, that's a lot more power than they have. But that's what they want. They want the power, and it's not so much about money as it is about power. And ultimately, they want you to surrender. That's what they want from everybody, okay? Because if you surrender and if you're out of the system and you surrender and get back in the system, then they have you under their control. They can take whatever they want, whenever they want, at any time. And anyway, so let's talk a little bit about the case. On March 29th of this year, after 8 years of struggle, 4 years I spent writing letters, trying to get them to follow the law. I should tell you that the lawsuit which I filed was under the Information Practices Act, and that's the State Privacy Act, and it's in the Civil Code in California. Now, the reason that that's important is because it's not in the Revenue and Taxation Code. If you think for a minute, if you have a tax problem, typically what would you do? You would go to the Revenue and Taxation Code, or you would go to the IRC and try to find a solution in there. Well, through study and just I happened to stumble onto it. Actually, I got started writing letters under the Privacy Act as a result of working with Free Enterprise Society and signing up for their program, and that's where I really learned to write these letters. It's analogous to the FOIA process or the Privacy Act request on the federal side. So the reason that this is so important is because, well, for a number of reasons. Refer to it as the IPA. The IPA is the Information Practices Act. It's found in the Civil Code in California in Section 1798, and it basically governs the kind of information that a state agency can have in their files about any individual and the way that they have to maintain that information. They have to have the source, they have to give you procedures on how to access the information, and it governs all that. So if they have information in their file, and they're using that information to assess me, and that information shouldn't be in their file, and I'm able to get that information out of their file, they have no file, right? They have no information. So what happens to the tax assessment? It falls like dominoes. Or the lien, it falls like dominoes. So my case is not a tax case, but it solved a tax problem. And I'll talk a little bit later about some of the other collateral areas that I think we might be able to look at. There are other states which have a Privacy Act, and I'll just read these to you, and if it fits in with where you live, and I have the sites where you can find it in the code, so if that's helpful, come up afterwards or during the question and answer, and I'll give you the site. But Alaska, California, Connecticut, Hawaii, Indiana, Massachusetts, Minnesota, New Hampshire, New York, Ohio, Utah, Virginia, Wisconsin, and Tennessee has, there's a reference here to Tennessee. It's not one of the 13, but there is a reference here. So those are other states that have some kind of a Privacy Act, maybe not quite as strong as California, but it's a starting point. So anyway, I went through 8 years of struggle. I started actually in about 1992, writing letters under the IPA. And another thing that I want to make very clear is that there's really two processes that were going on. And on one process is the standard where the agency is asking you for information. In other words, they're asking you for a return, they're asking you for other information, or then they make an assessment, they make a determination, well, they usually don't make a determination of deficiency, but they prepare a substitute for return, and then they issue a lien or a levy or so. That's their process, okay? The Privacy Act, or the Information Practices Act, or in the case of the federal, the FOIA and the privacy request, that's what I would call an interrogation process. In other words, you use that to interrogate the agency to find out whether they are meeting the requirements or not. And it's important in your mind to keep those, and in your files, to keep those two processes separate. So that they're writing you letters, you respond to those letters, but you're writing them letters, and they respond to the letters that you write. Okay? So I did that for 4 years, because in the California Privacy Act, they're prohibited from having personal information in the file. They're supposed to maintain the source of the information. They're supposed to provide me with the procedures to access the files, allow me to inspect the files, and a lot of other things. Well, they did almost none of those things, okay? Some of the letters they didn't even respond to. But after 4 years of writing these letters, I had no choice but to file a lawsuit. Now, in the Privacy Act, an advantage that there is under the tax code, or over the tax code rather, is that the Privacy Act is very short. It's only about 25 or 30 statutes, and they're very succinctly written. They're very clear. I mean, I use the phrase a third grader can understand them. And there's procedures in there to request the agency for information, for the sources, and also to delete the personal information from my file. Well, if they had deleted the personal information from my file, everything would have gone away, and I wouldn't have had to sue them. The information that they had in my file, which was not personal, was licensing information. I was a real estate broker. I didn't file returns, but they went to the city of Los Angeles and got the records under the business tax program, and they took an average for real estate brokers in Los Angeles County, and that's what they assessed me for. Now, what the state is doing, they have a $50 million program to integrate all these different techniques or sources. They use about 50 different licenses throughout the state. They use taxi agent, like the business tax. If you have, say, a transmission shop or a car dealer or something like that and don't file, then they would use that information and take an average. They use real estate sales and a couple of other sources. Well, any kind of an estimate is what? It's non-personal. So if they make any kind of an estimate and they put that in your file, it's non-personal. They do not have a right to have that in your file. So that's very important. Anyway, so that's what they were doing to me. And after writing all these letters, well, then we filed a lawsuit in 1997. I think it was May of 1997. And we lost the first trial. The judge was afraid to hear the trial. And the reason I know that is because he asked both attorneys to put up $125 for the transcript before the trial even started, number one. And then number two, he told my attorney, he said, because Derek, that was my attorney, or is my attorney, and he said, well, I'll just give a real brief opening statement, summarize it, because it's a very simple case, relatively. And the judge says, oh no, I want you to make a very detailed opening statement, okay? Take your time, get everything on the record. Well, why would you have to do that? Why would you have to order the transcript and get everything on the record, okay? So as soon as he sat down, the Attorney General got up and started his opening statement, and the judge interrupted him and said, I don't see any non-suit. Oh yeah, motion for non-suit, dismissed, and we're out of there, okay? Now, if the judge wasn't afraid to hear the trial, or to hear the case, in other words, he was afraid, he knew that case he was going to send it up to appeal, because he didn't want to make a decision against the Franchise Tax Board. This is the kind of corruption which goes on in the courts, okay? So that was actually turned out to be a blessing in disguise, because we had a bench trial, and later on we decided to go with a jury, which was a very, very critical decision. But then along the way there were motions. We filed an appeal with the second district there in California, and we won that appeal. The appeals court said, yes, Ballmer does have a case under the IPA for possible damages, and we will remand it back to the Superior Court for to determine whether there have been any violations and for those damages. So on March 29th of this year, I received a 12-0 verdict from the jury that the FTB had violated the law. And we only went to the jury with two questions, okay? One, did the FTB violate the IPA? And two, if they did, what are the damages that Ballmer's entitled to? That's all the jury had to decide, okay? Well, we had about 50 or 60 violations of the IPA. Now, any single one of those is probably not going to be enough to get any kind of a damage award, but you know, we had so many that we couldn't even get them all in during the presentation. But we used the most important ones. So one of the points that I want to make in using this interrogation system, or this interrogation process, which I call writing these letters, whether you're doing it in an attack in any kind of a case, is you might want to take a look at a book called The Art of War by one of the authors is a guy named Sun. And if you're familiar with that book, basically it's a way that you conquer a city or country without firing a shot. And you do that by basically getting inside and learning everything that you can about what's going on, and ultimately you take it over internally. So that was my approach, so to speak, or my idea in writing these letters, that I was just going to get every piece of information that I could possibly get. Another point that I think that's important is that to take the attitude that everything that the agency does, I don't care what kind of a case you're involved in, you know, whether it's an auto case or licensing or a traffic citation or tax case or anything like that, if you take the attitude that everything that they do, everything they say, every document that they produce, especially in the taxing agency, is wrong, okay? The task is to find out what is wrong. Now, sometimes that may take a long time. It may take months. I mean, you can't just look at it and make that determination on this file oftentimes. Sometimes you look at it and say, well, it looks okay to me. Take a notice of lien, for example. You know, I can look at that now and tell you what's wrong with it, but probably 3, 4, 5, 6 years ago, I couldn't do that. But that just comes with working at it and studying and learning what is going on. So one of the things I want to convey to you today is that there is hope here, there is possibilities and basically what I've done in California with regards to the state agency is just I've been able to open the door a little bit. I mean, yes, this was a big win, but it's just the beginning. And so I'm trying to find other people that will file a similar kind of lawsuit, and I'll tell you a little bit more about that in a few minutes. So, I'll just tell you briefly, the Federal Privacy Act was passed in 1974. I've already given you the 13 states that have State Privacy Act acts. The Civil Code in California was passed in 1977, but it has really eluded the Patriot movement for all of those 20 years because there are no appellate cases. When you go to the library, you just don't find any cases that you can refer to. But it's very well defined, it's clearly written, and it applies to all agencies. So I would think that in another state that would be probably the same kind of situation. Along the way, not too, actually it's just been in the last 7 or 8 months, I was able to get the manual from the state as to what they call their Personal Income Tax Non-Filing Enforcement Program. And they put out one of these manuals every year. They spent about $50 million putting together this computer program which integrates for any particular individual all these sources of non-personal information and other estimates which they get from the IRS and so on. In 1997, for example, they collected over $1 billion, with a B, $1 billion through this process using estimated information, non-personal information, which is in violation of the Information Practices Act. And probably something around 500,000 people that they're doing this to. So think of the fraud, the manipulation that's going on. Another example of non-personal information, what they're doing to me now is they took my mortgage payment and they arbitrarily multiplied it by 4. So if you ask them, well, first of all, they won't tell you what the source of the 4 is, but more importantly, the 4 is what? It's non-personal. It has nothing to do with me. Okay? So that's just another area that they're using. They're basically using any technique, any way that they can to issue a notice of proposed assessment, because when the people get the notice of proposed assessment, what? They don't have the ability to respond. In other words, they don't have the ability to take it to trial. So they end up having to surrender, to have their wages garnished, or to get another job, or to try and circumvent that some way. And the agency knows that, and they just use this hammer time after time after time. Just run through this scenario a little bit. Let's see, early 93, I responded to the first request for return. That was a 91 return. It was actually 91, 2, and 3, which was what I sued for. In early 95, I made a request for what's called a filing enforcement transcript in California. That's analogous to an IMF on the federal side. And that gave me the breakdown of the total income figure that they had on the notice of proposed assessment, and told me that there was this number on here, it was about $25,000 or $6,000 that they claimed I had earned as a real estate broker. Then in 96, I asked them to delete the information. They refused. Filed a lawsuit in 97. 2 weeks after I filed the lawsuit, they withdrew the liens that they had recorded at the county recorder. Interesting, huh? They also made a determination that I had no tax liability for 91, 2, and 3. So they come into court and they said, well, why is Ballmer here? You know, we don't understand this. We removed the liens, and we made this determination that it doesn't have a tax liability, so why is he still here? So if you think about it, and you remember I told you they were doing this to 500,000 people, they collected over $1 billion, they wanted to make sure that we never got the IPA issues in front of the court, because that's a big source of revenue for them. We had the first trial, I told you we lost that, we filed the appeal. In that appeal, the appeals court ruled that the FTB had no government immunity, and that's what the FTB was banking on. So, I might just tell you that we thought this was going to, my attorney and I, we thought this was going to be a 5-day trial. It was only 2 days, and part of that was because they had no defense. They had no documentation. They brought in no witnesses. They only cross-examined me about 15 or 20 minutes. They had done nothing, absolutely nothing to implement the IPA. I had about 70 exhibits that we could try and get into the evidence. We decided to only put about 20 or 25 of those into evidence because, I had so much information and so many exhibits and so many violations that we had to narrow it down. Otherwise, we would tend to confuse the jury. And this was one area that having an attorney really helped me, because being familiar with the procedures, having worked with, he's a trial attorney, having worked with many, many juries, and he said, Paul, look, we have to narrow down the issues, make it as simple as we possibly can. And, I was somewhat frustrated because I had all that, well, what about, number 59 and number 82 and so on and so on. It's just part of my perfectionistic approach, but in the end, it turned out to be very, very good advice. So we had 4 witnesses. I had been in some counseling, and so we were able to bring in that counselor because in the IPA, it allows for emotional distress, damages for emotional distress. Also wanted to get in a couple of other people that had experiences with the IPA, thinking that if I could flood the courtroom, so to speak, with other people that had similar experiences, why this would help sway the jury. Well, Heyman was one of those. He came, started to testify, got about 3 or 4 questions out, and the Attorney General jumped up, objected. The judge says, irrelevant. The judge says, sustained, and so he was out of there, and the other 2 witnesses that I had could not testify either. But we're going to take care of that in another situation here. So, another point that was very important that Derek did during the trial was to downplay the damages. And what I mean by that was he gave 3 different examples of, because when you look at, in other words, in most cases, like in a personal injury case, for example, you can go to the library and you can look up how much is an arm worth, how much is a death worth, and all these different things. Or in most tort situations, you can get a pretty close range, or at least some kind of a range. Well, when you look up emotional distress damage cases, it's all over the map. It's everything from 0 to 20 million. And so there was, and plus we had no cases to rely on in terms of the other cases under the IPA. So we wanted to downplay the damage amount. And my main interest was in obviously getting relief, but I wanted to make sure that I would get attorney's fees for Derek, and then hopefully would get something on top of that. But I think the 3 examples that Derek gave was maybe the highest one would have amounted to maybe $60,000, $70,000. But the jury decided that it was worth a lot more than that. And after all, I had put in 8 years, and it had really detracted from my business. I mean, there were times when I spent full time, almost for maybe a day or two, a lot of weeks in the library, a lot of support work for Derek. When I went to Derek, he said, Paul, he said, I don't have any knowledge of the tax code. And I said, well, don't worry about it. I'll do all the work. And little did I know. And you just put your name on the lawsuit, and there's a provision for attorney's fees, and we can get you paid for that, and you won't have to learn too much of the law. Well, 4 years later and about 300 hours later, well, fortunately we were able to get him paid. But we downplayed that, and that actually worked in my favor, because what it transmitted to the jury was that I wasn't in this for the money. And I often tell people when I talk to them about the tax movement and so on, that you don't get in this movement for economic reasons. Okay, $250,000 may sound like a lot of money, but keep in mind it took me 8 years, and I could have made probably 3 or 4 times that much money if I had not had the burden of having to answer these letters, and just the constant harassment, in one case where we wrote a letter to the state controller, she's the final person in the administrative process, and she sent it down to the taxpayer's advocate officer, who did 2 things. One is she wrote me a letter and said, I can't help you, and then she turned it over to the collection guy in Los Angeles, and he wrote me a letter and said, get your behind in here and tell me how you're going to pay this assessment. So that's the kind of harassment that was going on, where I was trying to get them to delete this information from the file, and they're just coming and pounding away, trying to make me surrender. Some of the things, and I'm sure if you've spent time writing any letters, even the IRS is famous for this. When they send you down dead-end streets, these rabbit trails which either end up in nothing or just take months and months of times. They refuse to allow me to inspect my files. They arbitrarily assess me based upon information which didn't pertain to me. They refuse to delete the non-personal information. And Kathleen Connell, who's the state controller, failed to designate an employee to resolve the matter, et cetera, et cetera, et cetera. So they don't think that they have to follow the IPA. They think they can do anything they want, and they've gotten away with it for 20 years, so why not? In other words, as far as I can tell, I'm the first one that has challenged them on this issue. So let me tell you a couple of things that with regards to that I learned out of this case that might apply in other situations for you. First of all, working with an attorney, although I've been in court quite a few times as a real estate broker, I've had a number of lawsuits and been involved with those and so on, and had a reasonable amount of experience. I just felt that it was really in my best interest to work with an attorney, and I would encourage you to either work with an attorney, or at least have an attorney coach, or at least work with paralegals through Freedom Law School, or work with somebody that is knowledgeable. Because, for example, during the week of trial, they filed, 3 or 4 motions. There were a couple of verbal motions during they submitted 3 motions after the trial. Dismissed for non-suit, dismissed for judgment notwithstanding the verdict. I didn't know what those were. A lot of, once again, terminology and procedures which can cut a person to shreds if you don't have a way to respond. Voir dire, that's where you question the jurors before you seat them. And what happened was juror number 15 had some experience with the SEC in some kind of procedural disputes and so on. And so I told Derek, I said, we have to bump anybody that we can, we have to get him on the jury, okay? And that turned out to be a godsend, because he ended up as being the foreman of the jury. And I'm sure he had something to do. The jury came up with, I think, $175,000 in damages, and then he told us this afterwards, he said something like, well, we should add interest on. And I think most people at the level of the jury members wouldn't think to add on interest. So this was very, very important. Staying out of the Revenue and Taxation Code. This was a collateral attack, and we wanted to make sure they kept trying to get it into the Revenue and Taxation Code to bring those in, make sure that we stayed out of that. We had a transcript of the assessment hearing, okay? You always want to take a witness with you, ideally, and a tape recorder of some kind. Well, I had this recording, and I had it transcribed, and we discussed this during my when I was on the stand. Well, we were able to get this transcript into the jury, and they read it, and they couldn't believe the arrogance of the appeals officer, because the appeals officer comes into the hearing. First of all, she doesn't have the authority, and secondly, she has this piece of paper that says you earned $50,000. Do you have anything that shows that you didn't earn $50,000? Well, what about the IPA? Well, we're not going to discuss that here, okay? That's not important. Well, what about your authority? We're not going to discuss that here. And this arrogance came out as a result of having this transcript. So that was something I did that was very, very critical. Some improvements that we're going to make this next time around is I didn't have the money to do depositions, and we're going to do the subpoenas a little differently. I'll tell you that story quickly. We walked in during the first pre-trial, right before we started the trial. It came up that the FTB had not answered the subpoenas. I wanted to subpoena and have 4 or 5 of these agents come in there and testify. And Derek had used what's called a subpoena in lieu, where you send a subpoena to the agency and they're supposed to bring the people in. Well, obviously the agency objected, but what happened is that the judge said, well, do you really want these people to appear? He said, if you do, I will issue a body attachment. Now, I've never heard of a body attachment, okay? We're in Los Angeles, the FTB's in Sacramento, and the judge says, I'll issue a body attachment. You get the paperwork in here in the morning, and I'll do that. And I was hiring a kite that night, because a body attachment is basically where the judge would send an order to Sacramento, the sheriff, and the sheriff would go to the FTB and arrest these people, put them on a plane, and bring them to the trial. Well, what happened, Derek stayed up to 9:30, 10 o'clock at night, did all the paperwork, took it in, and the judge changed his mind and wouldn't do the body attachments. But we'll get them, don't worry. But that's an instance where an attorney was very, very, I wouldn't have known what to do. I was working every night at the commission together to support Derek. So, but that was one instance where it's critical to have someone that knows what they're doing. So I want to suggest that we think about, and in the movement, we think about going on the offensive, which is basically what I did, okay? Because when you're on the defense, you don't have any real recourse anyway. What are you going to do about it? You always have to ask yourself, what is the ultimate end of this process? Where are you going to get relief? How are you going to get relief in a tax case? Well, ultimately, the only relief is going to be from court. So you have to be prepared to do that. And one of the problems I have right now, and one of the reasons I really appreciate speaking here, is getting the word out. In other words, I don't have a published case, but I'm in the process of suing them again, because now they're using the mortgage payment, the multiplier 4 for 1997 and 98, and they haven't learned their lesson. So here we go. I've already been writing letters for a couple of years, and a couple of other interesting things have come out. I have 2 other people that are going to join me. One has been fighting them for 20 years writing IPA letters. Another one has been writing letters for about 4 years. And we are going to file that lawsuit probably in January or February. We've got a few more things to do. But in the process, one of the people that I'm working with he filed a 0 return, and the Board of Equalization, which is like the tax court, they accepted his appeal. Now, in my case, they kicked mine out because I wouldn't file a return. But there's 3 other issues that I've been able to come up with that we're going to present to the Board of Equalization. And the reason that this is important is because we're using this as a test platform before we file a lawsuit, before we do the interrogatories, before we do the depositions. And those three issues are, first of all, they're supposed to provide on the Privacy Act says that on every notice, they're supposed to tell you who the manager is, how you can access that manager, the procedures to access, to find out whether that information should be in your file or not. They never do that. Never. Okay, number two is they never make, in the state of California, they never make a determination of a deficiency. If you look in the federal code or in your state code, you'll see that in order to have a determination of deficiency, you have to have a return. And there has to be a stated determination of deficiency and the reasons to do that. Well, California, they just issue the notice of proposed assessment. They don't screw around. They don't bother with a substitute for returns or anything. But here's the real kicker. The number three is that they don't have the authority, okay? And this is a if you don't take anything else away today, I'd appreciate if you would take this one point away, okay? And when I say they don't have the authority, what I mean, and this is the same situation in the federal case with the IRS, is that the authority, there's two lines of authority, okay? The one line of authority is from the legislature in California, it's from the legislature to the agency, to the executive director, and it's supposed to be to the employees, okay? So within the agency, but then that authority is also supposed to be delegated to the individual agent or the individual officer. That is where the breakdown comes. It never happens. And whenever you read a court case or look at any references, they always, if you're in court, the judge will say, well, the agency has the authority. It says right here in the statute. That may or may not be true, but the agent never has the authority. And the reason I know that, first of all, if you think about it, if you have a voluntary tax, you can't require people to do something. You can't authorize an agent to have the authority to collect that tax, okay? Now, what I did was I wrote an IPA letter, and I wrote it to the disclosure office, and the executive director, Gerald Goldberg, has the authority under the code to delegate any officer, deputy, agent, etc. For example, the hearing officer. For example, the person who makes the assessment. For example, the person who asks you for a return. Well, guess what? It came back and said, just send me any document. There's 7,000 employees in the Franchise Tax Board. Send me any document that shows where he's delegated his authority to anybody. No documents exist. In other words, there's no documentation that he's delegated any authority to any other agent, officer, or whatever in the whole agency. Then I wrote a couple letters to the two agents involved and said, where's their documentation? Well, their documentation is all blank. So we're going to get that issue before the Board of Equalization, because this next time around, we're going to sue the Board of Equalization and the FTB, because the FTB, in my appeal, for example, they asked me for my return. They say that they have that right. Well, if you look at the regulations on, they really don't have it. But guess what? They never sent me a privacy notice. In other words, they never met the IPA requirements under the Privacy Act to request a return from me. So they're in violation of the IPA also. Okay, so, all of what I'm trying to convey is that it all builds little by little by little. And you start at some point, and you take a step, you go to seminars, you study, you look at videos, you learn, you talk with other people. You don't learn it overnight, but you too can become proficient in this area. So this time around, we're going to be a lot better prepared. We have the money to do the depots. You see, we're going to go after these people now. We're going to have the time and the money. On the second round, the second case, we're going to get these agents in Sacramento, and we're going to depose them, and we're going to ask them, well, bring in your documentation for authority. Aha. So we're going to have that information before we even go to trial. Now, there's a couple of other areas that I want to just mention to you that you might want to take a look at as collateral areas. In other words, and these are possibilities. I haven't researched them, okay? All I'm saying is that there may be other areas that we want to look at in relation to the Internal Revenue Code or in relation to your state taxing agency. The Fair Debt Collection Practices Act, for example, the RICO. One of my goals is to put 2 or 3 or 4, as many as I can, of the people of the Franchise Tax Board, put them in jail or get civil judgments against them. Can you see the papers now? 3 FTB agents go to jail. Hooray. The recording laws, okay? There's the Bivens, what's called the Bivens type cases, the Federal Privacy Act, and I'm sure there may be some other areas, but some of these other areas may give us answers to attack the IRS. In closing, I'm just going to say that my suggestion is that you start today for a situation that you might encounter 3 years, 5 years hence. The preparation starts today. It doesn't start when you get the notice. In other words, if you haven't started the preparation and you get the notice, you don't have time. If you've got 30 days, 60 days, or whatever to respond, you're not going to have time to even think about it. You're going to call up a couple people. They're not going to know what to do. If you don't know what to do, if you have not done anything, you just don't stand a chance. Thank you very much.
He said a zero return, which I don't normally recommend. Didn't file a W-2 form with it, fortunately, or of any kind. But as a result, they sent 2 letters saying that, wait a minute, we sent a response to you before we looked at what you sent in. And they never used to do that. They said we are taking back our proposed tax assessment. They're taking back their word. They're thinking, they're slowing down. They're thinking a little bit more. They're not just rushing through like we always go through. And that's a start right there. And when he does his lawsuit, the next one has to be even better. I get my own lawsuits coming up. I'll be doing that. And others are. So those, and in a way, if you've been abused until we reformed them, you were lucky. You hit the jackpot. You know, hey, you could use a few $100,000, couldn't you? You know, and some people say, well, but it's the taxpayers that end up paying for these lawsuits that you went out. No, that's not necessarily true. Because eventually, at some level, these guys are going to have to explain to the taxpayers why they want to raise their taxes. We've been losing all these lawsuits because we're breaking the law. Well, you don't get to raise our taxes. You come out of your pocket, you know. So it will eventually come out of their pocket if you enforce the law on these people. And one of the things I've tried to do with Freedom Law School is to, when you get winners like Paul Ballmer or Dave Wellington or Bill Conklin or others that you see, is to record their success. So you don't have to completely repeat anything they do from the beginning from scratch. There's some record of it. And unfortunately, no one else was doing it. When I approached Paul, I said, look, let's get a transcript of your case. Let's do a course on what you've accomplished so other people can learn from that. They can modify to the situation. I don't think anybody else even approached Paul while I was doing that. You know, and all his knowledge would have been lost. You know, same thing with Bill Compton and others. So we want to bring this stuff to you for you so you could do it yourself. Or if you want, folks, we have, like I said, experts like Paul Ballmer available to consult with you. Okay? Ed Bruning, Dr. Robert Clarkson, Dave Wellington, Brett Ruff, and Paul Ballmer, and myself, there's 6 of us right now in a team available to assist you. Now, if you want to rather have someone do it for you, that's available also if you like. But it's up to you. If you want to win, if you want to live free now, it's possible. You just got to make a choice. Make a choice that you want to win, you want to live free now, and it's there. You just got to take the step forward. Okay? Okay, it's, why don't we take a 12-minute break? It's 11:30, 11:28. Let's take a 12-minute break and be back at 11:40 because our next speaker, Rich Diamond, I know many of you are really looking forward to hearing from him how you can make really bundles of money in real estate, no money down, no credit, no income proving to anybody, no bank loans. It's pretty exciting.